Hi everyone. The central government has filed an application in Supreme Court in the Ram Mandir case seeking restoration of 67.3 acres of land back to its rightful owners, the Ram Mandir. This application is coming up for hearing tomorrow in Supreme Court. The 67.3 acres of land lies adjacent to the disputed site in Ayodhya and was acquired by the central government in 1993 along with the disputed site, pursuant to the acquisition of certain areas of Ayodhya Act 1993. The disputed site comes to around 0.313 acres, while the adjacent land measures 67.3 acres, and the same was acquired on the ground that it is necessary for proper resolution of the dispute or to effectuate the acquisition. But what exactly is this application filed by the central government and what are the issues involved? Let us find out. The dispute itself has three legs. The first leg of this dispute cropped up in 1993 when the validity of the acquisition of certain areas of Ayodhya Act was challenged in the case of Ismail Farooqi versus Union of India. The Supreme Court delivered its judgment in this case in 1994. In its judgment, the court upheld the validity of the act. It also made it clear that Muslims have laid claim only to the disputed site which measures 0.313 acres and not the 67.3 acres adjacent to it. The Supreme Court also held that the acquisition of the adjacent land of 67.3 acres was only to ensure that the party which succeeds in the title suit is not denied proper access to the disputed site and for the enjoyment of the disputed land. However, the court also made it clear that the centre can determine the area needed for the above purpose and return the remaining land back to its rightful owners. Now comes the second leg of this dispute. This can be traced to a petition filed in 2002 by one Mohammad Aslam Bure in Supreme Court. Bure wanted to stop a Bhumi Pujan which was happening in the adjacent land of 67.3 acres. This led to the Supreme Court constituting a constitution bench to hear the issues relating to the adjacent land of 67.3 acres. That constitution bench heard the case and passed a significant judgment in March 2003. In that judgment, the Supreme Court held that the acquisition of the adjacent land of 67.3 acres is incidental to the main purpose and both the adjacent land and the disputed land are intrinsically connected to each other. So they cannot be separated and treated differently during the pendency of the dispute. Hence, the Supreme Court ordered status quo to be maintained with respect to the adjacent land of 67.3 acres till the Allahabad High Court decides the title suit. Coming to leg 3 of the dispute. The Allahabad High Court gave its verdict in this case in 2010, in which it ordered a three-way bifurcation of the disputed site of 0.313 acres. After the same, appeals came to be filed in Supreme Court challenging the Allahabad High Court verdict. The Supreme Court, while hearing the appeals, in an interim order passed in 2011, extended the status quo with respect to the adjacent land of 67.3 acres, which was given in the 2003 judgment in Mohammad Aslam Bure. Thus, the 2003 verdict being the backbone of the status quo, the central government has now filed an application for modification of that verdict. Interestingly, the central government has placed reliance on the other constitution bench decision of 1994 in Ismail Farooqi to seek this modification of the 2003 judgment. Some of the reasons stated by the centre in its interim application are: give effect to the mandate of Ismail Farooqi, which is the liberty given to the centre to return the superfluous land to rightful owners after deciding what land is necessary for rightful enjoyment of the disputed site. The centre has now stated that it has no objection to return such superfluous or adjacent land. Another reason given by the centre is that 25 years have passed since the land was acquired and the object of the Act, the Ayodhya Act, does not contemplate continuous vesting of the land. It defeats the temporary nature of the acquisition of land contemplated by the Ayodhya Act. What makes things even more interesting is the fact that, pursuant to the Ismail Farooqi judgment of 1994, the Ram Mandir had petitioned the central government to return the adjacent land in the late 1990s. The central government had, however, turned this down, and this had also reached the courts, and the court had also not interfered in that petition.